Good afternoon, everyone. My name is Catherine Fuller. I'm the managing attorney for the Paducah office of Kentucky Legal Aid. Thank you very much for coming out this evening to learn about getting your affairs in order. So just to tell you a little bit about myself, I obtained an undergraduate degree at Murray State University. I won't say what year. And a doctorate degree at Chase College of Law. Then in 2005, I accepted a position with Kentucky Legal Aid, and I've been there ever since, about 18 years. I continue to fight for the indigent, the underserved, and the abused populations in the area. My current focus right now is disaster relief as the vice chair for the Marshall County Long-Term Recovery Group. I'm also the first district representative for the Kentucky Lawyers Assistance Program. So who has heard of Kentucky Legal Aid? The whole room, I love that. So how many of you know what we do? Less hands, a little bit. So before we get started about getting your affairs in order, let's talk a little bit about Kentucky Legal Aid, who we are, what we do, and who we help. So what is Kentucky Legal Aid? We're a nonprofit social justice law firm. We help the indigent, the vulnerable, and seniors in the area, along with survivors of domestic violence, to obtain equal access to the court. We want everyone to have equal access to the court, regardless of their income. Our service area is composed of 35 counties, starting from South Central Kentucky through Western Kentucky. We have 4 fully staffed offices. The local office is here in Paducah. It's located at 216 Burger Road. We've been there since January of last year. We love our new building, so come and visit. We're a fully grant-funded program. All of our services are free of charge. You can't get much nowadays free, but you can get free legal advice, free representation with Kentucky Legal Aid. And you can also get free document preparation. We'll talk about that today. So there's some other programs across Kentucky. You hear Kentucky Legal Aid and you think we handle the entire state. Well, we do not. We have 3 other sister agencies that assist indigent individuals across the state of Kentucky. And this is their service area. They're in the yellow. That is Kentucky Legal Aid service area. For the Paducah office, we handle Lyon County, Livingston County, Callaway County, all the way over to the river counties. So we have a large geographical area to provide assistance. Our mission. The mission of Kentucky Legal Aid is to assist and enable low-income families as well as elderly, disabled, and other vulnerable individuals in Western and South Central Kentucky to resolve legal problems that are barriers to self-sufficiency. We look at it as a hand up and not a hand out. We connect people with resources and provide income stability, stable housing, and we help stabilize the family unit. Our impact. We help survivors of domestic violence escape abuse. We help people maintain their homes. We help fight evictions. We can help alleviate financial strains for loss of income. We can look at benefits, either Social Security, disability, or unemployment benefits to help stabilize the family. We are also a certified HUD counseling agency. I'm a certified counselor. If you're looking at purchasing a home, or if you're looking for loss mitigation, you're behind on your mortgage, you can't make your rent, give us a call. We may be able to assist you. Other impacts. We talked about that housing, employment discrimination. A new one back in 2016, Kentucky changed the law to allow criminal record expungements. So Kentucky Legal Aid, We handle most civil cases except fee-generating personal injury cases. We expanded our reach. We now do criminal record expungements, and that's one of my favorite areas of law. This helps people get a second chance for a clean slate, to get better employment, better housing for a mistake that they made in the past. So if you need assistance with that, give us a call. To receive assistance, you would call the intake department. That's the card I have here. That is the first step in the process for assistance. We're only one call away. If you need assistance with Kentucky Legal Aid, give us a call. So what do we do? Types of cases. We talked about that a little bit. We do family law, custody, visitation, divorce, child custody, domestic violence. We do consumer, we do collection defense, bankruptcies, Chapter 7. And then we also do credit report issues. We help people build their credit, housing, wrongful evictions, foreclosures, benefits, food stamps, disability, Medicare, Medicaid, and then the elder law, estate planning, last will and testaments, power of attorneys, and living wills. So now here's the big topic, getting your affairs in order. It's more of a legal wellness. I recommend, if you are 18 and over, that you have all 3 documents for your legal wellness. And what are those documents? I like to move around, so the living will, durable power of attorney, and a last will and testament. So show of hands, who has any of these 3 documents? Very good, very good. They're outdated. Okay. Well, it's a good step that you have it. You have it. And feel free, if anyone has questions, raise your hand. This is a very informal presentation. So just ask a question, and hopefully I'll have an answer. The first document that we will discuss is a living will. So what exactly is a living will? A living will is a legal document that encompasses your end-of-life decisions if you no longer have the capacity to voice your decisions. So if you're terminally ill, permanently unconscious, brain dead, that's when your living will come into play. And it tells your family and your doctors what you want done if you're on life support. The living will is governed by Kentucky Revised Statute 311-625. There's a packet that the statute says, a form, and I have the packet here that has the statutory form, and it gives you what the living will is, and it gives you a form to create one on your own. The living will must have 2 disinterested witnesses, or it must be notarized. It does not have to be prepared by an attorney, but it's always best to consult an attorney so you know what you're signing. You know what you're putting in there. I tested a platform the other day that created living wills. It was a kind of fill-in-the-blank question computer program, and it was very confusing. And I'm an attorney. I knew what those legal terms meant, and it was confusing for me. So I can imagine what a layperson would do filling out those forms. And I don't like that. I didn't recommend the platform to the manufacturer because I do not want people signing a legal document unless they understand what it does. So that's why it's always best to speak with an attorney. So the living will encompasses life-prolonging treatment. You either want life support until the very end, or you want it withheld and withdrawn so you can die naturally. Artificially provided food, water, and nourishment. That's IV fluids, feeding tube. That's another option. You can either keep all of that until the very end, or you can say, no, I want it all withdrawn. Let me die naturally. And it can be modified People can keep water until the very end, they can keep food until the very end, or they can say, no, I don't want any of it. So it's really a personal decision. But by creating this document, you are telling your family, the public, and your doctors what you want. You're taking that decision out of their hands, which is very important. Because the people I've talked to over the years, it's a very tough decision to pull the plug on a loved one. But when their wishes say that's what they want, you follow that. The living will also addresses organ or tissue donation. So in the living will, you appoint someone to follow your wishes. That person is called a healthcare surrogate. It can also be your physician. You do not want to appoint a family member, you can appoint your treating physician to follow your wishes. Why do I need a living will? Again, if you don't have one, your family makes that decision. Very tough decision. What will happen if I do not have a living will? Again, the family makes the decision. I have a living will, what do I do with it? So you've made this document, now what? Well, you take it to your medical provider. They can incorporate that into your medical record, so that is in your medical file. I advise people to take it to the area hospital of your choosing, and they can incorporate it. I mean, how many times do we go to the hospital and they ask you, do you have a living will? So once you create that document, you can say, yes, I have the living will, it's on file. So it's a very important document. A living will is not a last will and testament. We'll talk about what that is later. It's not a do not resuscitate order. And it doesn't contain general medical treatment. I've had people that would want to put, I don't want open heart surgery in there. No, this is not the place to put that. This is end of life decisions. This is the end of the road. If you never get in that spot, then it never comes into play. The Terry Schiavo case. Is anyone familiar with this? Back in 2003. In Florida, Terry Schiavo, she was only 26 years old, and she had a cardiac arrest. Her brain was deprived of oxygen, but she was still alive. They worked with her for a little bit, but the doctor said she was pretty much brain dead. She was in a persistent vegetative state. She was married, did not have a living will. Her parents were alive. And for 4 years, her parents and her husband cared for her. Her husband met with the doctors, parents too, and they told her that she would not improve. There was nothing more that they could do with her. So the husband said, I don't want her to live like this. She told me she did not want to live that way. I want to take out the feeding tube. I want her to die naturally. Her parents said, no, that's murder. I do not want to starve my daughter to death. They went to court. 19 judges heard this case. Litigation, the media blew it up. It was the right to die case. And after a long court battle, the husband won. The husband removed the feeding tube, and Ms. Schiavo died naturally. But goodness, what an experience. 19 judges. There's no telling how much they spent on legal fees, court battles, and the media. What would have prevented this if she had a last will and testament, if she had a living will? 26 years old, you would think, I don't need a living will. Anyone 18 and over needs a living will. So moving on next is a do not resuscitate order. A lot of people get this confused with a living will. This is a totally separate legal document. A do not resuscitate order pretty much tells paramedics and doctors if you go into cardiac arrest, do not perform CPR, do not intubate, and do not use the paddles. They are not going to try to revive you if you have a DNR. It's a very serious legal document, and when I prepare these, I make sure the person fully understands what this does. I tell people to carry this with you at all times, because if you've made the decision not to resuscitate, you want that document with you. Because if something happens, the paramedics are going to try to revive you unless they find that paper, and they also make like a medical bracelet that says DNR. So if those are your wishes, again, communication is the key. Any questions about living wills or DNRs before we move on to power of attorneys? Okay. The next document that I recommend to get your affairs in order is a durable power of attorney. So what is a durable power of attorney? It is a legal document that gives another person the power to act on your behalf. So this can be very broad. Most of the power of attorneys that I prepare encompass all legal powers. If you can do something legally, then your power of attorney would have the authority to do that also. They can access your medical records, they can access your bank accounts, they can transfer your property, they can do anything that you can legally do. So it's very important when you appoint a power of attorney that you trust that person, because they can have access to anything that you have. Most power of attorneys that I prepare prohibit gifting property or changing beneficiaries on life insurance policies. That just protects the grantor, because those are really personal powers, giving your property away. So unless the person granting that wants that in there, I usually omit those powers. Why do I need a power of attorney? Well, if you get in a situation and you are no longer able to handle your own affairs, if you have Alzheimer's, dementia, hopefully that will never happen, but if it does, you really need a power of attorney. You need to give that power to handle your affairs to someone else, because if you don't, the court will do it. And that is a very traumatic experience. If you do not have a power of attorney and you're disabled, can't handle your own affairs, then your family must petition the court for guardianship. So that's a little costly. Plus, the person that you're wanting to have the guardianship over must go through a jury trial and be adjudged incompetent. So to avoid all of that, it's best to have a power of attorney. That way you decide who handles your affairs, not the courts. You keep the power to handle part of your affairs if you get better, versus the guardianship where they take that away from you. When will my power of attorney be effective? So we can make the document effective either immediately, as soon as you sign it and it's notarized, the person has the power to act on your behalf, or the safer option, which I recommend, upon a disability. So then that person that you appoint will not have that power until you're physically or mentally incapable of handling your own affairs. Power of attorneys are governed by Kentucky Revised Statute 457. You want some interesting reading? Oh. Check out that statute. So power of attorneys, again, beware, only appoint someone that you trust. I don't know how many times I've heard, oh, I appointed my daughter and now she's got a substance abuse issue. She took all of the money from my account. What do I do? What do? You revoke that power of attorney when you have any indication that the agent, the person you appointed, is breaching their fiduciary duty. And you can revoke the power of attorney at any time. I have an example of a power of attorney revocation up here. It basically just says, I no longer want you to have that power. I hereby revoke it. I advise people that are revoking their power of attorneys to send a copy of that revocation by certified mail to your agent. That way they can sign the green card and you'll have proof that they received the revocation. Because once they receive that revocation, they cannot act under that power of attorney. I also advise people, if there's a financial institution that has that power of attorney, give them the revocation also, so they know not to deal with that one person. The power of attorneys, the agent that you appoint, they're supposed to keep records and documentation of any transactions that they have. So when does it end? You have a power of attorney, you decide not to revoke it. When does it end? Does it ever end? Death, very good. And if it's durable, if you have a disability, it continues. If it's not durable, it stops upon your disability. So if you have a power of attorney, you want to make sure it's a durable power of attorney. And again, we do power of attorneys free of charge. Take an intake card if you would like that. Any questions about power of attorneys? Very good. We've got a quiet group this time. Next, we will move on to last will and testaments. The purpose of a last will and testament is to give your property to whomever you choose upon your passing. It's basically what it is. So you want to make sure that you have a last will and testament, because if you don't and you pass away, then your property will be distributed according to the laws of Kentucky. So they're taking that power out of your hands, and Kentucky is telling you how your property is distributed. Who would want that? Anyone here? Does anyone here want Kentucky distributing their property upon their passing? You definitely need a last will and testament. And this is governed by Kentucky Revised Statute 394. A common misconception that I hear all the time is, oh, isn't it a law that I have to leave my children something? No, it is not. I tell people, it's your property. You do not have to leave your children anything. You don't have to leave them $1 or 50 cents, anything like that. You do, if you omit your children, you do need to specify the intentional removal of them from your will, though. That's just making it clear that you know who your children are, you know your assets, and you don't want them to receive anything. It's your property, you do what you want with it. So if you pass away without a last will and testament, you're married and you have children. Who gets the property? No, that's a common misconception. If you pass away, no. Give them time, though. No. No, if you pass away without a last will and testament, you have a spouse and you have children, it does not automatically go to your spouse. Half goes to your spouse, half goes to your children. Is that what you want? I wouldn't want that. I have a spouse and children, and I would want to receive everything for the benefit of my children. So that's why, another reason you need a last will and testament. What are the requirements of a last will and testament? Well, you have to be over 18, you have to be competent, and competency is not as strict as the competency required for a contract. You basically have to know who you are, who your children are, your heirs, and what property you have, and what you're doing with the last will and testament. You must be a resident of Kentucky. You cannot come to Kentucky and do a will if you're a Tennessee resident. You must prepare a last will and testament in the state that you reside. It must be voluntary. No one can force you to execute a last will and testament. If they do, it's not valid. It must have 2 witnesses, and they must see you sign the document. If you have 2 witnesses there, you bring a will in and it's already signed, that's not going to work. There's strict statutory requirements for a last will and testament, and it must be followed to a T to be legal. Now, there is an exception to that, and you won't hear a lot about it because private attorneys don't want you to know about it. I'm not a private attorney, so I don't get paid, by the hour or by the word. But there is a document out there called a holographic last will and testament, and it is a legal, valid document in Kentucky. I've got an example here, and what you do is you just take a piece of paper. You use the language there. It's just I, my name, on this date hereby make the following bequest. And as long as the document is dated entirely in your own handwriting, signed by you at the bottom, it's a legal will. Now, how simple is that? You don't have to worry about the witnesses. It doesn't even need to be notarized. The big requirement is it must be in your own handwriting. So if you use my example there, write it out, sign it, you have a will. I've seen fill-in-the-blank wills on the internet. Those are not valid. Do not waste your time or money on those fill-in-the-blank wills. They are not valid. The document must be entirely in your own handwriting to be a valid holographic will. So if you do not want to come to Kentucky Legal Aid to have us prepare it, you want it done right now, tomorrow, take an example, write it out, and then take one of my intake cards, and I can look at your holographic will and give you some advice. So that's a little quicker process. So feel free to do that. When should I have a last will and testament? Of course, it's your property. When you want it to go to specific people, it's necessary. But if your child receives SSI, which is an income-based program, it's supplemental security income, and you have assets to leave to that person, it needs to be done in a testamentary trust because their income is sensitive. It's need-based, and they can only have so much in resources and assets. So if you want to take care of your disabled child that receives SSI, even if it's an adult, it's best to do it by a trust. That way they do not lose their benefits, specifically Medicaid. Most people with SSI, they need a lot of medical care, so you don't want them to lose that Medicaid benefit. And the way we can do that is to put their assets in a trust in the last will and testament. And the trustee can buy things for your SSI son to help preserve benefits. Whereas if you just left them your house or your bank account with, say, $10,000 in it, that would automatically disqualify them from their SSI and their Medicaid. So we do this at Kentucky Legal Aid. We specialize in that. So if you need assistance with that, please give us a call. Can I change my last will and testament? Yes, you can change it as long as you're competent. As long as you know what you're doing, you can change your last will and testament. Now, I recommend, if you can do an amendment to your last will and testament. It's called a codicil. I don't recommend those because it's hard enough to keep up with one piece of paper, let alone two. So if you have your will here and you amend it with a codicil, but the codicil gets lost, then you just have your will. So I advise people just revoke the old will and do another one. That way you have one document and there's no confusion. When should I change my last will and testament? Anytime you have a major life event, marriage, divorce, separation, birth of a child, death of a child, you move out of state, those are times to change your last will and testament. Now, if you move, say you're a Tennessee resident and you decide to move to Kentucky, you have a valid Tennessee last will and testament. Is it valid in Kentucky? Who thinks it is? No one? Who thinks it's not valid in Kentucky? Oh, it is valid in Kentucky. Surprise, surprise. Kentucky gives full faith and credit to properly executed documents in sister states. So as long as it's a valid last will in Tennessee, Kentucky will recognize it. But I always tell people if they move to a new state, update your documents to avoid any confusion. It's all about keeping it simple, avoiding confusion, and you can do that by updating your documents. Let's see. Once you create your documents, your legal documents, do not write on them. I don't know how many times people have come into my office with their original last will and testament, and there's markings all over it. She's like, oh, I just made a few changes, here you go. And I'm like, oh, you just invalidated your document. It's best not to write on it. If you want to make changes, call an attorney or do another document. Again, to avoid that confusion and avoid the issue of invalidating your last will and testament. So what is probate? A lot of people are afraid of probate. They hear probate and it's a bad word. It's not a bad word. It's a little complicated, yes, but if your estate is under $30,000, you're a surviving spouse or a surviving child, there is a simple way to dispense with administration and make it an easy process. And I've got the guide to probate up here, a very informative packet. Most probate procedures have standard forms. You just fill out the form, take it to the district clerk, and file it. So inheritance tax, I'm not a tax attorney, never liked tax law. I've got a packet here. Inheritance tax, they look at the relationship, the closeness of the relationship with you and the testator. So most surviving spouses and children, close family members do not have to pay inheritance tax. It's mainly, if you leave a friend something in a will, then they may have to pay the inheritance tax. Again, if you have tax questions, it's best to ask a tax professional. So overall, getting your affairs in order. If you do not have all three documents, please grab a card. Let's take care of your affairs today. Let's get that in order, or at least make a step in the right direction to avoid all these issues that I discussed earlier, because they do arise. I hear all the time, well, my children get along. They'll be fine. And then mom passes away and here comes the kids. Well, I want this, she told me to have that. You don't want that for your family. It's not a good experience, it's costly, and it's best to avoid that. And to avoid all those issues, create your documents. Communicate with your family. Let them know your wishes. Well, you've been a great group this evening. Thank you very much for coming out. I appreciate it.